Welcome to the What's Happening Birmingham video podcast.
Hello everyone, this is Jarvis Escott with What's Happening in Birmingham. I am back with attorney Kem Marks of Part 2 of Just in Time Legal Solutions, and we're talking about child custody. So thank you all for watching the first video. I knew if I put it long in 10 minutes on y'all wasn't gonna watch, so I'm splitting this thing up to talk about custody because that's a topic, a whole other topic. So attorney Kem Marks, thanks. Welcome back again.
Thank you.
All right, so let's kick off the first question. How do the courts determine who gets custody?
Well, most of the time, if it is a divorce situation, the court looks at the best interest of the child. Now, when it's unmarried parents, generally initial custody, just for purposes of legality, custody lies with the mother, unless, of course, for some reason she's proven unfit.
All right, so that being said, so what do the courts mean by the best interest of the child?
That just means that children certainly should be raised in safe environments that are clean and with good emotional support and things like that. And so it's just what environment is going to best allow that child to thrive. And now the thing about the law, though, is it presumes that unless a parent is unfit, those parents are going to always act in the best interest of the child.
All right, so I know the majority of people may be watching this segment might be men. So attorney Kem Marks, what are fathers' rights?
Well, fathers' rights are things that I think sometimes men, in being first-time parents, don't understand how to approach. There are several things that men can do to preserve their paternal rights. One being, and again, a lot of this is going to deal with unmarried parents, because I think that, you know, we would probably have to do one that just dealt with a divorce situation and then custody. So, but in an unmarried parent situation, you have an opportunity where a dad can sign a birth certificate or not at the hospital. If that dad signs the birth certificate, then at that point, that is a presumption of paternity under the law. Now, the issue though is that if he signs, that establishes some degree of paternal rights, but if he signs before having a DNA test, for example, then he's going to potentially be assessed with child support, even if he learns later that that is not his child. If he signs before negotiating whose last name the child is going to have, it's a lot harder to fix that on the backside of it. And so those are things that before signing on to voluntarily establish paternity, men should think about those types of things, because they do have a degree of bargaining power at that point.
So if I have just a little doubt, I shouldn't sign that paper.
Well, if you don't want to voluntarily be responsible for 19 years of that child, then no, you should not.
Oh, wow. So that gets me to the next question, of which a lot of you fellas probably watching this video want to ask, what can I do if she won't let me see the child after the court said he's allowed visitation rights? What process?
Well, let's step back a little bit and talk about establishing your custody and visitation, meaning that, you know, again, in an unmarried parent situation, even if the father signs the birth certificate, or whether he signs it or not, the court is going to have to issue a visitation order. So there's no absolute right of visitation, and there's no means of recourse. There's nothing you can do about it if you don't have a visitation order and a mother that's an unmarried parent stops you from seeing the child. So the first thing to do is to establish your visitation schedule, establish your joint legal custody, which is not to be confused with physical custody, and then go from there.
So what do you do if they violate the visitation orders or anything? You just have to keep going back to the court to just say, hey, she didn't do this?
Essentially, you do.
Wow. Okay.
It's a contempt situation. And so the key to it is being very diligent about being on time for your court-ordered visitation and taking good notes and documenting that you're on time, that you did show up. Do not engage in verbally abusive or threatening social media communications or text messaging, or any of those things, because those are kind of considered self-help types of things. You know, if you don't have my child here by a certain time, I'm gonna do this, or, you know, if you do this again, those types of things are proactive, are not good towards custody. So it really is best to just leave it with the court system.
Let's talk about social media for a moment. You know, social media uses all our people that's on Snapchat and Instagram and Facebook and the different things like that. Can you tell people how that impacts, or what advice do you give to your clients if they're going through child support, custody issues? Do you tell them, like, maybe you need to log off, or maybe you need to take those pictures down, or?
Well, I think that social media should not be used as a tool either positively or negatively to influence court-ordered visitation or custody, because I think that to the extent that, let's just go from the positive side first. So someone who wants to establish visitation, or a mom who wants to show that she's a good mom, may take all of these, you know, staged moments and photos and put them on social media. But at the same time, you know, that could be a source of frustration to the other parent. That places the child, who is a minor, you know, at undue risk for their safety in getting caught in the middle between whoever it is that may be bitter about, you know, not being able to see the child or be a part of different activities and things. And so that's just not a good situation from the positive side, because if you're at, you know, the school program and all of your family's there and you're streaming live, well, something like that could prompt an angry father to just, oh, well, I'm just going to go over to the school now. And that's a confrontation that did not have to happen, you know, based on trying to taunt or flaunt some sort of custody situation. Now, the other side of it is that certainly you don't want to engage in any, you know, shaming or threatening or aggressive conduct on social media, because that documents a pattern for the court that could later be used against whichever parent is before the court at that time in a negative way.
Okay, so another thing I know, like, you fellas are listening, how about I like to just go for the home run and I just want full custody?
Well, that is possible depending on whether the mother is fit. If you're dealing with an unfit parent, then certainly a dad should pursue his rights for the health, welfare, safety of a child. But keep in mind, in terms of doing it just as a form of emotional blackmail, or not in the best interest of the child, or avoidance of child support, those efforts are unlikely to be successful. If you have a physical custodial mom who is doing everything that she needs to do, and the children are well taken care of, then the most that a father is going to be able to get under those circumstances is a joint custody situation.
All right, and I know a lot of you all probably thinking, like Attorney Mark said earlier, it's like for every instance you got to go back to the court. So I know a lot of you fellas probably thinking, like, look, I'm strapped for cash, so I'm just gonna go myself. Can you tell them some of the disadvantages sometimes of trying to handle these issues, child support, custody, on their own instead of bringing an attorney?
Well, I think so. If your choices are going to the court versus not, definitely go. But I think one of the pitfalls is that legal terms and the way that the law works doesn't always comport with how people understand that things should go. And so a lot of times people will file things and they think it's the right thing, but it's the wrong thing. And unfortunately, the court can only determine what it is that you're asking for in your filing. And so if you filed something and have asked for the wrong thing, then the court's just going to dismiss it once they determine, well, no, you filed this, but you should have been filing that. And the court isn't going to do your legal work for you. And so essentially, you know, if there's some long narrative that's handwritten that doesn't address whatever evidence needs to be shown in a certain matter,
Okay.
then the court's gonna toss it out. I mean, you've said a whole bunch of stuff, but you haven't said the things that are going to be outcome determinative in terms of the court making a decision. So an attorney will address whatever issues and whatever facts need to be established to get you where you need to be versus just putting in a lot of things that are not going to be helpful in the end.
Okay, so you're watching this video, or you're watching it somewhere across the United States. We're in Alabama. So your experience lately in the courts handling this, what are some things you've seen in the last few months?
Well, I have seen that, again, people need to, some of my clients have been surprised at the difference of treatment they've received,
All right.
for example, in having an attorney versus not having an attorney, meaning that I think that the courts are respectful of attorney's time. If you're paying someone to be there on the clock, then we're going to go ahead and get you in and out of the way, as opposed to people who may have just taken off work to be there on their own. So that helps to have an attorney. If you're running late, as long as your attorney's there, your attorney's paid to be there on your behalf. And so if you're running late or can't show up, there's someone to speak up for you and say, my client's running a few minutes late, we can go ahead and get started because I'm here, or we can wait for the client. And it stops the other person from saying, see, this is what I go through. This is why we
Judge, this is why she is.
Right. So these are the things that having kind of that attorney there as your representative, eyes and ears in the court, just kind of keeps things on track a lot more than they would otherwise be.
So my final question, this is an easy question of the day. If they would like to contact you and hire you, what's the best contact number and information? Where are you located?
Oh, I'm located right here in historic downtown Bessemer. Our address is 1922 3rd Avenue North, Bessemer, Alabama 35020, and our telephone number is 205-436-2846.
All right, and just final thoughts, because you all probably been watching both segments. What you just want to tell the viewers that we haven't already covered today?
Well, in terms of full custody, I did want to clarify that neither parent has full custody.
All right.
Once a guy's rights are established, meaning you said, well, what if I want to be a guy and quote unquote go for full custody? And I said that you would have to prove that that mother is unfit. Well, the same is true. If a guy has a child that's established to be his child, he automatically gets visitation and joint legal custody if he asks for it. And unless when he makes his request to the court, the mother can show that he's unfit, then the court isn't going to in any way deny visitation, in any way deny just basic access to health records, medical records, school records, and things like that. So, essentially sole custody is very rare. It's just that men a lot of times don't know that they, once paternity is established, have legal custody.
All right. Well, Tony Marks, thank you for coming on today for the 2 segments. Thank you all for watching the videos. Please check out what'shappenedbirmingham.com for more videos, and don't forget to subscribe to our YouTube channel. Thank you all again, and have a great day. Bye-bye, and call this lady if you have child support and custody issues. Bye, everyone.
Thank you for watching the What's Happening Birmingham video podcast. Please check out our website, app, or subscribe to our YouTube channel for the latest videos today.